owners oftentimes view the litigation as not to their benefit, even if they're aware that there are significant defects and significant repair costs, because they realize this could really hamper their ability to move if they want to.
Welcome to the Uncommon Area, where we're dedicated to reimagining HOAs. We provide board members and managers with the resources to create uncommon communities where residents love their HOA and truly love where they live. Welcome to the Uncommon Area. I'm Matthew Holbrook, and this episode is all about construction defects. Joining me to talk about this very important topic is Joe Smith of Berg Simpson Law Firm. They are based in Colorado, and Joe provides a really good perspective and introduction as to how to think about defects that might be in a community association and what a board of directors might do to pursue remedies for any defects that might be in the community. So I hope you watch, and I hope it's beneficial for you. Thank you, Joe, for joining us for this episode in the Uncommon Area. And we're going to be diving into construction defects. So maybe just by way of getting started, can you define for us, what do we mean when we say construction defect?
Yeah, thank you for having me, Matthew. It's a pleasure to be here with you today. You know, some states actually define construction defect. And those obviously can be defined differently, but generally when we're talking about construction defects in the community association world, you can think of something that was either designed incorrectly or built incorrectly. And the things that we look to define whether or not the design or construction was correct would be things like the plans and specifications that are approved by a building department, building codes themselves, and then other industry standards like a manufacturer's installation instructions, for example, for a stucco system or a roofing system. So anything that violates those primary standards can be considered a defect. Then the issue is whether or not the defects are significant enough or pervasive enough to warrant considering potential litigation.
Generally speaking, there are multiple solutions to addressing defect situation for an association. In other words, litigation is not the only way to go. Talk for just a minute how an association might address a defect issue that arises in their community before they might necessarily need to pursue litigation. How might there be a more amicable resolution?
Yeah, sure. We definitely think that litigation would be the last resort after you've tried several things that might end up in what you're talking about, an amicable resolution. The first would be for the association, either through the board or through a community manager, to go back to the builder or developer and simply notify them of the concerns or the conditions that are of concern and see if they'll come out and actually address it. Oftentimes there are warranties that would be available to the association or individual owners where technically the builder or developer are required to come back in order to try to address the conditions. And then there are statutes throughout the country that oftentimes have what I call a notice and repair process, where the association, before it can even file a construction defect case, would send a written notice to the builder or developer, other potentially responsible parties. They often have the right then to do an inspection. In some states, they have the right to actually make a repair. In other states like Colorado, where I am, they have the right to offer a repair, and then the association can either accept or reject that offer. So ideally, that notice and claim and inspection process will resolve the potential issues without the need for litigation. That's certainly, I think, one of the big intents behind those statutes. Oftentimes we don't see that actually resolving things, but there are definitely avenues to pursue that are informal or maybe a little more formal, but not rising to the level of litigation at the outset.
Now, you mentioned different statutes in different states. Are there dramatic differences about how to pursue this type of resolution from state to state? And maybe, if you know, what are some of the outlier states that might be more dramatic than others in their differences?
Yeah, I think although I would say most statutes in the construction defect world have a lot of similarities. There are some significant differences. One big one I would say is the right to repair. So a lot of those statutes are described as a right to repair statute when in fact many of them don't include the actual right to repair. Like I said, in Colorado, you get the option as the association to consider an offer to repair, but you're not bound by what is offered to you. In Arizona, a builder or developer has the absolute right, upon receiving a notice of claim, to come in, do their inspection, and then actually say to the association, okay, we've seen your community, we agree these defects exist, and we're going to do the following repairs. Most states have a time frame attached to that. The builder developer can't just leave an open window and say, we'll do the repairs, but not give a sense for when or how long that might take. California is similar. They were, I think, a front runner in the right to repair process. Texas, like Colorado, has a notice and offer of settlement type process. But I think the biggest difference that you're going to see out there would be whether or not the folks you send a notice to have the right to come in and make repairs or the right to make an offer. And then it's up to the association to decide whether or not that offer is reasonable and worth considering or ultimately accepting.
So, considering those differences between states, when an association is considering that they do need to pursue a legal route to get resolution on defects, what are some of the things that just generically, regardless of the state that you're in, that a board of directors should be weighing and considering when they're thinking about pursuing litigation for a defect?
I would say the first thing, and this I don't think naturally pops up to a board, but the first thing they need to be considering or thinking about is a timing concern. There are what are called statutes of limitations across the country, and then statutes of repose specific to construction defect litigation, which can impose, in some cases, as short as 1 or 2 years after a defect shows up or is noticed in a community to actually pursue litigation. A statute of repose is more of a safe harbor. It says typically from the date of substantial completion of the community, if defects don't show up, let's say within 6 years or 7 years, the builder and developer are generally going to be able to know that they're safe from being sued for any defects. So in a 6-year statute of repose state, if a defect first shows up, let's say 6.5 years after substantial completion, then that community may already be out of time. Now, I would say, and we often say to boards and community managers, don't ever make that decision on your own as a board. Always seek advice from a construction defect attorney because these statutes, limitations, and repose can be very fact specific. And there also are ways or sometimes even statutory processes that allow you to toll or stall the statute of repose or limitations, meaning the clock can stop ticking for some period of time. Beyond that, I think that a primary concern or thought for a board up front should be, does it seem to us that the conditions that we're concerned about are localized or are they seeming to be widespread across the community? Oftentimes that's a function of how many homeowners may be reporting a common condition to the community manager or to board members, say at meetings. Because oftentimes, even if a defect exists, if it's really narrowly focused, let's say we have a 10 building community and it turns out that just one building has a particular issue, say with respect to window installation, that defect on its own in 1 out of 10 buildings may not be worth pursuing for various reasons. And so it's always important, I think, for the board to get assistance in determining, are the conditions widespread enough or significant enough that you need to then think about the additional steps that might follow. I would say to do that, oftentimes you do want to get a construction defect attorney in early. Oftentimes they will bring a forensic engineer or forensic expert with them to walk the community in order to help the board determine what sorts of defects may exist, how extensive are they, and then the lawyers can work with the board to determine yes, they're worth pursuing, or no, they're not, or maybe they are, but let's go through some of these more informal processes first, see if the builder, developer, design professionals will come out and address them.
So, working through what you just said, kind of the highlights are make sure that you understand what time factors that there might be for a board to consider, whether it be some type of statute of limitations or other timing mechanism that could pass, and the association might forego its right to pursue litigation to resolve a defect issue. And then you are also bringing up the importance of identifying any issues that do arise, and to have that discussion with legal counsel and other experts to determine, do these defects rise to the level that it makes sense and is worth it to go through a litigation process. So those are kind of, if I'm hearing you correctly, kind of summarizing your two main points, I think. Do I have that about right?
No, that's a real good summary. I think I would add to that then also evaluating the governing documents to make sure that at the outset, the board's taking into account whether or not a condition that may be questionable or of concern is something that the association would ultimately be responsible to maintain and repair or replace, meaning the association would be the party to pursue that potential defect claim. Or is it something that the individual owners are responsible for? And therefore, early on, the board may need to be recommending to those individual homeowners. It doesn't appear to us as the board that the governing documents make the association responsible for the condition. So you as individual owners will need to go out and explore the viability of potential claims, maybe a recommendation from the board for those owners to reach out to the builder developer if it's early enough in the community's life, maybe to submit warranty claims on the individual owners, by the individual owners, in order to see if the builder developer will deal with them directly.
So going back to, you brought up the idea of tolling agreements to essentially put a pause on the time limitations. To work from that, does an association have to have reasonable cause for concern about a potential defect in order to put a tolling agreement in place? Or could an association put a tolling agreement in place if they are aware that they're bumping up to a statute of limitations and they want more time to be able to evaluate?
I think an association can do it either way. I think that ultimately, whether or not a tolling agreement is going to be put in place is really going to depend on the builder or developer or other potential defendants and their appetite for stopping that clock from ticking, which for them is a positive thing, the clock ticking and running through a statute of limitations or oppose, versus wanting to really try to address the issues and resolve the claims up front. There certainly are builders and developers that we've worked with who recognize that litigation is not good for them. It's not good for either side at the end of the day. The cases are expensive and risky. And so we've seen developers enter into those either early on when there really is no time pressure, or later on when there is more time pressure. I think what an association needs to get traction with the builder or developer on a tolling agreement is going to be some fairly detailed information about what their concern is. I don't think that going to a builder or developer and saying, hey, out of our 300 units in the condo community, we've got 10 units that are reporting water intrusion through their windows. We'd really like to work with you, developer, builder, to figure out what's going on, but we're aware that there may be time limits and we want to stop those from running. I don't think you're going to get much traction in that situation. So I think that there's going to have to be some legwork done by the association to be able to put some meat on the bones of what their concerns are in order to get some traction on that early tolling agreement. Otherwise, I just think that a builder developer is going to say, look, these are maintenance issues. These aren't something that are significant enough for us to be worried about. And so there's probably not a lot of likelihood that a tolling agreement arises out of that sort of very preliminary, superficial situation.
So I think that there are a fair number of board members and maybe even some managers that might be under the impression that they can just essentially file a tolling agreement automatically at any given time. And I think what you are highlighting is that it's an agreement actually between two parties. And in order to reach that agreement, there needs to be an incentive on the builder's side of the equation to say, hey, it is in our interest to put a pause on the timing, which means that there has to be some element to that that gives the builder reason to believe that there is the possibility of resolution, maybe in a more favorable kind of a way. Whereas if they don't agree to a tolling agreement, then the association's alternative is to immediately start down the road of the litigation, which may not be in the builder's interest. Am I summing that up correctly?
Yeah, that's a good summary. A tolling agreement is definitely an agreement. It's a written contract between two or more parties. And so I always recommend to associations that they initially have their general counsel working with the builder developer folks to put together a tolling agreement. Oftentimes, I think that if that tolling agreement or communication comes from a construction defect firm or construction defect attorney, it creates the wrong impression for the builder or developer that somehow the association has already decided it's going to head down that road to litigation. But definitely need legal counsel involved, because at the end of the day, you need a written agreement that's going to spell out the specific terms of how that tolling works, when it begins, when it might end automatically, or how it would end if one or the other side wants to terminate it. So it can get complex, and definitely not just something you'd go out and file with a court or a clerk and recorder or something like that.
Sometimes it seems that a builder might have an incentive to want to see the association file that lawsuit and begin the process of litigation, because maybe that triggers the builder's insurance coverage in some way. Is there any validity to that perspective? And does that affect how an association might strategically approach this kind of a situation where they know that, hey, maybe we need to do something to trigger that insurance coverage, which might make the builder more amenable to how these issues could ultimately be resolved?
Yeah, you're right on there, Matthew. Oftentimes, in order for a builder or developer to get their liability insurer involved with the process and potentially providing money to defend the case, or more ideally to resolve the case early, they do need something more formal than just a letter, say, from the association's board, or even a tolling agreement. In most states, that's going to be this initial notice of claim that I talked about a little while ago. And basically, it is generally a letter. I'm not aware of any statutes that require some specific format or form to be used, but the notice of claim would go to the builder developer, say, here's what our concerns are. In Colorado and Florida, at least, that notice of claim is enough to constitute a claim for insurance purposes. And so in that situation, a builder or developer receiving the notice should be able to pass it along to their liability insurer, and then get attorneys involved at that very early stage, as well as the insurance company starting to analyze the potential case. I will say one other nice thing about the notices that go out before litigation in most states. Typically, those are going to toll the statute of limitations right off the bat. And so where an association may not be able to work out a tolling agreement with the potential defendants, the notice of claim, rather than having to jump right into a lawsuit, the notice of claim normally is going to toll or stop that clock from ticking for whatever that notice of claim process may be. Here in Colorado, that's typically going to be 75 to 90 days, just based on the letter of the statute, the face of it. That can be extended by the parties. But yeah, I think a notice of claim is typically what's going to trigger the potential for insurance coverage. And I have some thoughts on how that plays into whether or not litigation ultimately happens, if you're interested in them.
Yeah, of course. Go ahead.
Yeah, so obviously insurance is important to builders, even the biggest builders in the country. And so I think there's a plus and a minus to the insurance carriers getting involved. On the plus side, I think that it gives the builder developers insurance defense attorneys very early in the process that should be familiar with construction defect litigation in the state where the project is located. And I think the more that you have good insurance defense attorneys involved, the more likely there's going to be a positive outcome or a reasonable outcome as far as most folks are concerned. Um, on the negative side, I would say what we tend to see is that the insurers are not eager to start paying out money to settle these cases very early. And so oftentimes, even though the association may be filing the notice of claim or serving the notice of claim, maybe they're very short on the statute of limitations. Maybe communications have just broken down between them and the developer, and they know this is the next step, a way to ramp up the pressure a little bit. But I don't believe that every association that has an attorney send a notice of claim wants to get into litigation. They want to get the builder developer's attention. And so I think, unfortunately, once insurance companies are involved, they assume that litigation is going to go the long haul, and they're fairly comfortable with that. That's just the way they operate in our experience. So, pluses and minuses, I think, to getting the carriers involved. I think, in the overall scheme of things, better to get the carriers involved early, in particular the insurance defense attorneys. And I think in a lot of states, these construction defect attorney communities very small between plaintiffs and defendants. And oftentimes I find that attorneys have really good working relationships across the table. And so that oftentimes can help maybe spur discussions that weren't happening before the notice of claim ended up going out.
Strategically, do you think about an approach with a builder any differently based on how experienced they are in building HOA or condo associations? So, for example, let's say you have a builder who has historically built commercial buildings and then they venture into a residential condominium building, and this is their first or second project like that. They may not be as well versed in some of the ins and outs of the defect process. Does that matter in any way strategically to how an association might go about pursuing a claim?
I don't think so. I think maybe I might have more optimism that a commercial contractor who's branching out into multifamily um, would be maybe more sophisticated and be more interested in those early discussions without the need for construction defect being on the horizon. But I think as far as the process goes, I think that associations should assume you want to do it the same way you would do it regardless of who the builder or developer is. That way you're not missing a step. You're just checking the boxes along the way. And then hopefully, if they are more sophisticated, then that should, I think, at least open the door to a higher likelihood of resolution through the notice of claim process. At the same time, I'll say we have had cases against builders who are just branching out into the townhome or condominium community world. And I think oftentimes they don't appreciate that, in fact, the notice of claim is not just a preliminary step the board's jumping through or hoop they're jumping through to get to litigation as soon as possible. So um, I wouldn't approach it any differently. I think that, again, the key is probably to get insurance involved as early as possible and good insurance defense counsel so that then the attorneys can ideally help work through that notice process and maybe even get it set up in a way that an early resolution would be possible.
So taking a step back for a minute, going back to the statute of limitations or other time factors, would your recommendation be that an association that is coming up on one of those time limitations, that they proactively engage with an attorney and or experts to be able to do a full assessment of their community to determine what, if any, defects they might have, even if they are not aware of any at the time?
That's an interesting question that we deal with pretty frequently. I and we are not big fans of going out into a community that hasn't been dealing with issues just because they're getting close to a statute of repose end date and trying to find problems. A lot of states have up to 10 years for that statute of repose. Some states recently are shortening them from 10 to 7. That happened in Florida and Oregon in the last couple of years. Here in Colorado, we have a 6-year statute of repose that in unique circumstances can get out to about 8 years. Um, I think that ordinarily it's probably worth an association getting close to the statute of repose, considering having some sort of forensic consultant come out, a forensic engineer, a forensic architect, even maybe a contractor that deals with defect litigation frequently or maybe just on occasion. I think it's worth having them walk the community with the board, community manager, and at least putting an eye on things. Um, but I don't think the idea should be let's go find something. It's really just to be maybe overly proactive. And if there's really something significant that shows up, investigating it quickly and deciding whether or not there's something that needs to be done. I'll say in our experience, typically well before the statute of repose might be coming up, the communities are experiencing problems and they're not having to deal with that sort of conundrum of do we just move through the statute of repose end line and not worry about if we have issues, or do they maybe have someone come look at the community beforehand?
So along those lines, how do you address the critique of the legal defect side of the equation, where you are incentivized to find defects in order to make your living, and maybe that is pushing certain associations into a long litigation process that has a lot of downsides for the association when maybe they didn't need to go that route in the first place?
I understand the perception, and I understand that technically there probably is that sort of appearance of a conflict of interest. I think though most plaintiffs, construction defect attorneys that I've known over the years, um, I don't think many of us actually approach these cases with that sort of lens. First of all, I think regardless of what state you may be in, um, there's more than enough significant construction defects sitting out there that all the plaintiffs' firms are plenty busy. I don't think that any of the plaintiffs' firms I'm familiar with are having a shortage of work at this point. And so just from that standpoint alone, I think most plaintiffs' firms, certainly the way that we approach potential cases is with an eye towards, is it really in the association's best interest to go down that road? Because as you say, there are significant risks. And these cases can be very long to resolve. We typically recommend that folks think on the order of 18 to 24 months after the notice of claim process is resolved, or has ended and not resolved the case. Um, the reality is, I think that plaintiffs' attorneys don't go into communities looking to drum up defects, because most of us are representing our associations on a contingency fee basis and advancing the costs of the litigation, filing fees, all the expert costs, deposition costs. And on big communities, that can be significant. It can get to 7 figures in some cases. And if we don't recover anything for the association, we don't get paid fees. And a lot of attorneys approach it as though they're not going to ask for those litigation costs to be reimbursed either. So from an economic standpoint, maybe there's very little risk to the association in that situation, and that the risk is borne by the attorneys. And trying to drum up defects or trying to drum up damage, because oftentimes insurance isn't even triggered until you get actual damage occurring from the defect. There's not a lot of incentive, I think, to go trying to dig up defects that aren't already manifesting themselves and proving to be very pervasive or significant for the community.
So related to that, what are the downsides to an association for going through defect litigation? What are the negative things that they're going to experience along the way?
One thing that the individual owners in a community involved in defect litigation are going to experience is difficulty either refinancing or selling their homes. Most often, we see that your traditional mortgage lenders won't lend in a community that's involved in defect litigation. And so that oftentimes limits sales to cash buyers only. And I think you need a pretty unique cash buyer who's willing to come in and purchase a home in a community that's known to be in construction defect litigation. So I think that is a risk. And I think that owners oftentimes um, view the litigation as not to their benefit, even if they're aware that there are significant defects and significant repair costs, because they realize this could really hamper their ability to move if they want to. I think the folks usually most concerned about that are the folks who already have their homes on the market at the time the defect litigation is first being talked about. Um, the other downsides are the association is going to be asked in all likelihood to not repair the defects or the resulting damage for the duration of the lawsuit, because these cases are so highly dependent on the actual condition of the buildings or the units or the common areas throughout the community. Typically, unless there's a need for an emergency or a safety related repair, the association has to preserve that evidence of those conditions. And so, from the standpoint of the association, if they have grounds that are pooling water and pushing water up against the buildings, which could already be creating problems or is likely to lead to, say, maybe foundation movement in the future, they're being asked not to make those repairs. Owners are being asked not to repaint the insides of their units. And oftentimes for boards, I think their biggest struggle during a lawsuit is that sort of tension that builds between the owners and the board. The owners want to be able to maybe redecorate or renovate the inside of their home. They want to be able to sell it. And to do that, they feel that they need to paint everything so it looks fresh and updated. At the same time, the board, through their construction defect attorney, is telling the homeowners, we really are asking you not to do that because we need that evidence. We need the defense experts to see it. So those are a couple of the big things. Um, Reserve studies, those tend to not really be a big issue, but for an association that's already reserved money, say, to paint the outsides of all of their 10 buildings, again, because of the need to preserve evidence, oftentimes we will recommend that they skip that ordinary or sort of cyclical maintenance, at least in the buildings involved in litigation, if not all of them are. And then you oftentimes get the homeowners complaining, wow, these buildings look old, they look faded. So I think a lot of times for the board, it's just sort of the internal community politics. For the association, the biggest risk and downfall is that there isn't enough money recovered to do all of the necessary repairs, which can put the association obviously in the position of either needing to levy a special assessment against the owners or potentially go out and try to get a loan to fund those repairs. But as you and I both know, in order to pay off that loan, probably a special assessment is going to be needed at some point further down the road. So that, I think, is the biggest risk to the association. Their attorneys, their experts have now documented various defects throughout the community. There's a cost of repair associated with that. And if there's a shortfall, it may trigger some of these needs to go out and get funding in a way that isn't going to be convenient and that some of the owners may not even be able to afford at the end of the day.
Yeah. And I would just add to your list, you also have in the process of the litigation, the potential for things like destructive testing that could create a certain level of inconvenience to the owners going through the process. I wanted to ask, is there a typical kind of moment of truth that comes up in the litigation process? It's like normally right here at this stage, this is where, it's going to kind of make or break the case. Is there anything typical along those lines, or is it just different in every case?
No, I think there are a few common things. One is going to be the expert depositions. Those are normally going to happen fairly late in the case, probably maybe 3, 4 months before the trial or the arbitration. And if you happen to get an expert who missed something during the intrusive testing or during their inspections or their analyses, um, it can really hurt the association's case because now at a deposition, they're under the same oath they would be at trial or arbitration, and they can be impeached with whatever they have to admit to that they did wrong. And so if an expert, say on a stucco system, were applying the wrong manufacturer's installation instructions or the wrong code provisions, and it turns out that the way the builder did all of that work at the time of the original construction, it was acceptable. Now those claims that lots of money and lots of time have been spent on uh, are probably not viable. They could be subject to a motion for summary judgment, which would kick that claim altogether. So the expert depositions and having good experts is absolutely critical to the strength of every association's case. Normally, construction defect attorneys will have folks they've worked with for years who are trusted, who we know they can testify well, they can back up their opinions, and they don't miss things when they're out doing their investigation and analysis. Another really critical point, I would say, is when the association's attorney can finally get detailed information about the builder or developer's insurance coverage. More and more, we're seeing project-specific insurance policies issued, which have a certain limit. So let's say maybe $5 million for all liability that the builder may face at that particular community. And most often, those policies are what we call eroding policies, meaning every dollar spent for the defense attorneys, every dollar spent for the defense experts, every dollar spent in depositions that the defense attorneys are there or have their experts at, that $5 million is being eaten into or eroded. So if you have a significant case, let's say you have a $10 million construction defect case, that's your cost of repair as determined by the association's experts. But your builder developer was one and the same, and they only have a $5 million eroding limits policy. You may not ever be able to get more money out of them, particularly if they've gone bankrupt or just have dissolved, whatever it may be. And so that insurance point, or the point at which you can determine what coverage is really out there, can also be a make or break point. There are definitely cases that construction defect attorneys on the plaintiff side have handled where they've got to say to the board, yes, you have a very strong case. There is no way to recover anywhere near that amount of money because of the builder developer's financial situation and insurance situation. And so what we need to be doing now is shifting gears and talking about settling the case ideally as quickly as possible for whatever's left on that policy. And then the association working with contractors and engineers after the fact to try to use that money as broadly as possible to cover as many of the defects as possible. So I would say that the expert depots and the insurance coverage analysis are probably the two biggest make or break points in these cases.
Yeah. How often does a case actually go to trial versus settling? Kind of what's the breakdown on that?
I would say in the construction defect arena,
Yeah.
probably 97, 98% of cases are going to settle before trial or arbitration. That's definitely our experience year in and year out. We may have an anomaly here and there as far as having more cases go. Across the country, frankly, in civil cases, more than 90% of those actually settle. And so we're just at a higher level than that. And I've always attributed that to the fact that in a construction defect case, whether or not the community was designed or built right is pretty black and white. Like I said, there are building codes. There are other standards that are going to tell you whether or not the community was designed or built correctly, as opposed to, say, automobile injury cases. If I get rear-ended on the way home today, maybe I have very little tolerance for pain compared to my passenger. And so those cases are very, very much dealing with gray issues, I think.
Yeah.
So in the construction defect arena, I think they settle more frequently because they're pretty black and white. The question's not so much is the builder developer going to be liable. I would say every case we've had, over my experience, the defense experts do ultimately agree that there are certain defects that exist that require repair. So that is them having to go into that trial or arbitration and admit liability. Normally, the grayest area in these cases is what's the right scope of repair and what's the right cost of repair.
Yeah. Well, I think my last question for this episode is around the ideal dollar amount for a settlement or a resolution. And what I'm specifically getting at is when factoring in attorney's fees, does an association need to get actually more money than what the cost of repair is? So if they have $10 million worth of repairs, but they're going to pay their attorney some amount of that, they're going to have less than $10 million to do the repair. So they need to get more than $10 million. Talk about that as a potential reality. And if so, what does an association do about that?
Yeah, that is absolutely the reality. Whether the association's paying an attorney hourly, a flat fee, or contingency, obviously that's taking money out of the association's funds, if you will. The nice thing about a contingency is that only happens if there's a recovery. There are states where it's possible to pursue various different types of damages that may actually allow associations to settle where their net settlement, which is the money they are actually given after fees and costs are paid, is at or very close to 100% of what their experts have determined is the scope and cost of repair. There are other states like Colorado where that's simply not possible. You can only go into a settlement conference and ask for damages that you can actually pursue at the arbitration or the trial. And so if on a particular case, I don't have a basis to argue that the other side should be responsible to pay the attorney fees, I can't add to my settlement demand that $10 million cost of repair plus a contingency, because the other side is just going to say, we'll never have to pay you the fees, so we're not even going to talk about them in a settlement. That's the unfortunate reality of the way our American civil system works in most cases. But there are other damages that oftentimes we can pursue that are above and beyond the actual cost of repair that may help defray some of the attorney fees that have to be paid and make that net closer to the full cost of repair than it otherwise would be. One advantage is typically across the country, the litigation costs should be awarded to the prevailing party. That's typically by statute or court rules, can also be by contract. And so typically you can add to that $10 million the cost of the litigation expenses that say the plaintiff's firm had advanced. So ideally you have your cost of repair and other damages amounts that you can add to a settlement demand, and you can get the other side to agree to settle the case for as close to that initial demand number as possible. The reality is, I think that most associations should approach construction defect litigation anticipating that their net recovery will not be 100% of their cost of repair. But I also think that the engineers and the contractors who specialize in post-litigation repair work have ways that they can help to streamline certain repairs. They can sequence things in certain ways that oftentimes allow the association to stretch that net farther than it might appear just by the actual dollar amount compared to the original cost of repair.
I think it also puts the association in a position where they are likely including claims within the association where there maybe are genuine defects, but they may not rise to the level that the association feels that they have to repair those defects. And so they may get recovery for those defects, even if they may not end up making those repairs. And that helps to get additional dollars.
Right. So maybe that could be a technical code deficiency or violation of the code that hasn't resulted, say, in water intrusion or resulting damage. You're right. That's something that probably at the end of the day could be, that dollar amount could be shifted over to other repairs. I think that happens quite a bit in these cases. And honestly, I think that because an association really only gets one shot at construction defect litigation, it's not unusual for the association's experts to want to do the intrusive testing, for example, that you mentioned, because you just don't know what's going on behind the stucco or the siding or the brick. And you really do want to try to find all of those defects that are present without obviously deconstructing an entire building or an entire unit, so that you have everything from the truly significant, obvious defect that's causing water intrusion, maybe mold growth and damage to the wood framing, to maybe those items that might be technical code violations, because you get one bite at the apple. And then at the end of the day, the association can work with its contractor and design professionals to figure out how to really use those dollars to stretch them across as many of the repairs as possible in an initial round of construction.
Yeah, that's great. Well, Joe, thank you so much. This has been a really good kind of introduction to defect litigation and to addressing defects in a community. I know that there is a volume of information on this that we've barely touched, but I think this is a helpful introduction for a lot of board members and managers. So thank you so much for your time and for your expertise on this. I really appreciate Joe and all of his insight and input regarding construction defects in community associations. I hope that you found this episode to be helpful. And if so, I would encourage you to like this episode and to subscribe to the Uncommon Area. And it would also be great if you would tell someone else about this podcast so that they could benefit as well.